Thank you. Please be seated. Good morning. We're here for oral argument in case number 1, CACV 16-0620, DAQ Corporation versus INTRAVEST 2851 Kathleen LLC. Council, a couple of reminders. We're recording this by video and also audio, so we ask you to please identify yourselves and who you represent at the beginning of your arguments. Each of you have 20 minutes in which to argue. Appellant's counsel, if you watch the clock and reserve as much time as you deem appropriate for rebuttal. And also, please keep in mind that we have read the briefs and have discussed this case in conference this morning. And with that, counsel for appellant, you may proceed.
Thank you, Your Honor. And I'll, in terms of reserving time, I guess it's my own, I'm on the clock.
It's good.
Yeah. Good morning. May it please the court, Art Bork on behalf of the appellant, who I'll refer to as Kathleen. I referred to the entity, the LLC, as Kathleen in the briefs. I'm going to talk about two issues, and both are hurdles that brokers in Arizona need to jump over in order to get real estate commissions. The first is they've got to establish that they complied with their fiduciary duty to their client. It's the first issue. The second is the broker has to show that it complied with Title 32, starting at the statute's 2101. If a broker doesn't jump over those hurdles, it's not entitled to compensation. If it does, it is. So those are the issues before the court that I'm going to address. I'm not abandoning the other three issues: mutual mistake, unilateral mistake, and adverse inference jury instruction. If the court, of course, has any questions on those issues, I'm very happy to answer them. But I want to focus on breach of fiduciary duty and the statute, because I think that those are the most precedential issues. They're of statewide importance, and realtors are doing thousands and thousands of quote-unquote deals each year, so you're going to have a recurring issue. Breach of fiduciary duty. I gave the trial court instructions from two cases, a 1973 case called Ornamental and a 2014 case called Focus Point. And what I didn't know when I gave those instructions to the court, that each of those courts was dealing with an allegation that there was an improper law. On Ornamental in 1973, it was a bench trial. The trial court said basically you need to prove fraud and damages to prevent a realtor from getting a commission. And the Court of Appeals reversed the trial court and said, no, you just need to show breach of fiduciary duty. And what the trial court did in Ornamental is it said, here is what breach of fiduciary duty is. And I quoted that real estate agents required to protect and promote the interest of the client and to deal fairly with all parties to the transaction. He is held to the, or she is held to the highest ethical standards of fairness and honest dealings. That's a basic hurdle that every real estate broker and every lawyer and every other professional who owes a fiduciary duty to their client has to get over in order, in this case, to get a commission. That's the black letter law in Arizona. I thought it was an uncontroversial instruction.
Counsel, is your argument here that, or the allegation at least, as that there was a breach of the fiduciary duty in connection with the second transaction? You're not suggesting, in other words, you're not suggesting there was any breach of fiduciary duty in connection with the first transaction?
I'm suggesting there's a breach of fiduciary duty with both transactions, which are one whole, Your Honor. And what I mean by that is when my client purchased the property, the realtor knew that it was going to be what they call a flip. They were going to sell the property. So he induced them with, you will pay a 2% commission to me, and you will pay a 2% commission, a rich fee, to an outside broker. Right? Now, the 2% fee to the outside broker, and this is Exhibit 8 before the trial court, the realtor said, you need to pay this 2% commission to the outside realtor because it'll stimulate interest and you'll get a quick sale, and the price is probably going to be higher with this 2% to the outside broker. Then what does the realtor do? Instead of 2% to the outside broker, gives 1%. It disincentivizes the outside broker. And this is the exact problem with these undisclosed fee agreements. they're hurting their own client by, instead of giving the outside broker 2%, they're disincentivizing that person to go out and find buyers. And sure enough, it took 2 years to sell the property. And to Your Honor's question again,
how does that relate? I'm having a hard time making the connection to the 0.5 commission, which is really the only issue before us. Correct? Is the 0.5% commission or amount, whatever you want to call it.
That is the compensation that is sought, and that's the only compensation. That's the only issue before the court. The fiduciary duty, though, it was intertwined. When Mason Cave in Exhibit 11 said to the realtor, said, "Hey, I know you're getting 2% on the original deal, and hey, I'll offer to pay an extra 0.5% on the second deal." Those were combined, and in fact, Your Honor, in Exhibit, I believe it's 27, that's Mr. Lundstedt's August 6, 2014 email to his boss. He himself combines the two. He says to his boss, "Hey, boss, we're supposed to get 2% on this deal, and we're supposed to get a 0.5% on this other deal. We've already taken 3%, so we're already up an extra point." They already, and by the way, he admitted at trial that taking that extra point was over and above what he was allowed to take. He said, "I took that over and above my agreement." So it's really the breach of fiduciary duty instruction related to the way the entire deal went down. And I don't think you can separate it, Your Honor, because they're combined. Even Mr. Lundstedt thought they were combined. And by the way, when Mr. Lundstedt wrote that email, Exhibit 27, to his boss, and that's the email that we had to get from the escrow agent, they didn't disclose it in their disclosure statement. He said to his boss, he combines the deal, and then the boss writes him back, Mr. Jenkins, and says, "No, these are two separate deals." So the only guy who negotiated this transaction, Mr. Lundstedt, combined the two. So it's all part of one, Your Honor. The second case, the Focus Point case, which was decided in 2014 by this division. What's interesting in that case is the appellant who was sitting in my shoes said to a panel here, said, "Hey, panel, the judge required intent to prove fiduciary duty, and the judge screwed up." That's the Focus Point case. Well, what the Court of Appeals said is they inferred, yeah, intent is not good. You don't need to prove intent for fiduciary duty. But what they said is the judge didn't say that to the jury. The judge made an errant comment 5 months before trial on summary judgment. So this court gave the correct instruction to the jury, which is the instruction that I requested. That Focus Point court holding, I didn't know when I cited it as a jury instruction, the Focus Point court holding is that intent is not an element of fiduciary duty. And that's exactly what the trial court did in this case. It required us to prove a false representation. And there's no rationale given whatsoever. Now, did we have the goods? Did we have the evidence to support the fiduciary duty instruction? I think we did. And the solicitation email that I talked about, that's Exhibit 8. Mason Cave's response, "Hey, you're owed 2, I'll pay an extra 0.5%, so you'll get 2.5% when we close." And then ultimately, Exhibit 27, which is Mr. Lundstedt's email to his boss, and he admitted at trial, I think that captures my agreement with Kathleen, and I cited that admission. So, and again, what you have here is two things on the fiduciary duty breach. You have a realtor saying, I need you to pay 2% to this outside broker. I know it's a quote-unquote rich fee. But then what he does is he goes out on the street and says, "Hey, who wants this deal for 1%? Now, it's only common sense that he basically diminished the interest in that property, didn't do what he said he was going to do. I asked him at trial, did you intend when you wrote that email that you were going to actually give the outside broker 1% and take 3% for yourself? He said, I don't know. Here's the other problem on the breach of fiduciary duty. This deal is not the broker's deal. It's the two parties' deal. And the case law is quite clear. If there's extra profits from a deal, the realtor doesn't get it as part of his fiduciary duty. Any incidental profit goes to his client. And in this case, it's even more straightforward because you have this admission that the deal was 2.5%. So to me, that's very, very clear. You have everybody agrees on the law of fiduciary duty. We had the evidence for that to go in front of a jury. We were denied that going in front of a jury. And what went in front of a jury was not only a wrong instruction, but it was a fraud instruction. And I mentioned this in a brief, but I think it's kind of axiomatic here. I have to use a big word, I guess. If you can instruct the jury, basically as the trial court did, on a fraud claim, right? He said you got to prove false representation to get fiduciary duty. Well, the trial court's implying that we had the goods to meet the fiduciary duty instruction, which is a lot less evidence to prove breach of fiduciary duty than it is to prove fraud. So I think the trial court told us that we had enough evidence. So that's fiduciary duty. Title 32, and the statute started 2101. It's very, very simple. If this is a real estate employment agreement under 2151.02e, then Kathleen wins. And Kathleen wins because there's no expiration date on the email that they're relying on. That's Exhibit 27. Starting in
sorry, as a side point, the requirement is also needs to be signed by all parties to the agreement. Do you concede that the email exchange satisfies that fourth requirement?
Great question. I thought about making that argument. You know, the Young v. Rose case, 2013, the client wrote back, I think they said, or the realtor wrote back and said, thanks, right? My client wrote back and said, confirmed. I'll tell you, I thought about making it, but I thought it was weak, so I didn't make it. Okay. I took the low-hanging fruit.
I just wanted to know what your point was.
Yeah, and I thought long and hard about that. Can't talk about attorney-client privilege things, but I thought long and hard. What's not there is the expiration date. And if you look at the kind of cases that have occurred since 1977, it's a cat and mouse game with realtors, and the realtors always lose when they don't follow the statute because it's binary. It's not horseshoes or hand grenades. You either comply with the statute or you don't get a commission. Olson v. Neal is a 1977 case that I cited, and that court, the realtor tried to say, oh, it was a waiver. There was a real estate employment agreement had expired. Court said, the trial court ruled in favor of the realtor. Court of Appeals said, nope. Going back, we do not allow parties to get a commission if they don't strictly comply with the statute. We're not like other states. One of the most important cases is the red carpet case, and that's 1981. That's another attempt by a realtor to play around with the language of the then regulations. And the red carpet court said, you've got to have a definite start date and a definite end date. And that is when it was a regulation rather than a statute. The statute was promulgated in 1995 and then expanded, as I mentioned in my papers, in year 2000. So, real estate employment agreement. What is a real estate employment agreement? It's this simple. And this is the statute, 2151.02e. It's a written agreement, which they're relying on, that 0.5 agreement, to enable a broker, Dahm is suing broker, that's the second thing, to compensation. And compensation is very, very broad in the statutes. 2101, 32-2101-16 defines compensation as anything, including a contingent obligation. That's 2101-16. And the fourth element is it's for services. And it's brokerage services. It's very, very simple. It points to the statute of frauds. Services pursuant to 44-101(7). What does the statute of frauds cover? That covers an agreement that authorizes or employs a real estate agent or broker to buy or sell property in exchange for compensation or a commission. And
Counsel, what's wrong with the trial court's reasoning here, which was quite simple in the sense of just saying, look, this is just an agreement, a separate agreement, had nothing to do with the listing agreement. It was an agreement to make up the difference. It was an agreement to make up this 0.5% at a later date. It really had nothing to do with the transaction. It was a side note. What's wrong with that?
It's What's wrong is, first of all, Your Honor, the rationale of the trial court is, hey, we already have a listing agreement. The seller already agreed to pay money, right? That's on the sell side. The seller reduced that from 2.0 to 1.5. In order for DAWM to get a commission, right, there had to be an agreement with Kathleen. There was an agreement. That begs the question, what kind of agreement is it? It's an agreement for brokerage services. If you look at their complaint, right, their complaint says it's an agreement for brokerage services. Now, there's exceptions in Title 32. You'll find them exception for, like, when a broker does property management. There's an exception where a broker does a power of attorney. But you can call it an agreement to make up this or that. But the question is it an agreement for compensation in exchange for brokerage service? What was Mr. Lundstedt doing for Kathleen? It was brokerage services. And so it's a separate agreement for brokerage services, for compensation, and it's really that simple. Where the court erred, Your Honor, the initial trial court, he said that, hey, there's already an agreement here that complies with the statute, but that was on the seller side. To get a commission off the buyer, they've got to comply with the statute, which they didn't. And
how often does it? Well, it's not going to be in the record, but as a practical matter, how often do buyers pay a commission in a real estate deal?
You know, I don't know the answer to that question, Your Honor. I do know this: the statute says buyer or seller, and if you make an agreement where a buyer is going to pay a commission in exchange for brokerage services, and by the way, Your Honor, the complaint just doesn't say that. It's verified by their designated broker. Guess what? Who is the most experienced person in this entire group of people as to what brokerage services are? Listen to what DAWM said. And what's happening now, Your Honor, is it's being re-engineered. Right? The entire case has been re-engineered. When you hear the word, oh, this is just a simple agreement, what that is that's code for ignore everything but that email, ignore the solicitation email, ignore what happened afterwards when Mr. Lundstedt makes a bunch of admissions, including at trial that he was overpaid. Ignore those things and, hey, this is a simple agreement. Well, it's so simple it didn't contain an expiration clause, and for that reason, we ask you to grant judgment in favor of Kathleen because it's clear non-compliance with the statute. Alternatively, if the court didn't find that that was appropriate, then we would ask you to reverse and remand for a new trial and give the instructions that we've requested. Thank you.
Thank you. Counsel?
Thank you. Good morning, Judge Campbell, Judge Perkins, Judge Brown, Robert Mitchell, Tiffany and Bosco on behalf of the appellee, DAQ Corporation, which does business as DAWM Commercial Real Estate Services. The majority of the appellant's argument on appeal has been resolved by not just one, but two Superior Court judges, Judge Randall Warner and Judge Douglas Gerlach, who both concluded that the agreement that is in dispute in the case below, the September 24, 2012 email agreement, was not a real estate employment agreement, a legal term specifically defined by statute. Both judges concluded that this email agreement was simply an agreement between DAWM and the appellant, whereby DAWM would agree to forego payment of 0.5% of the commission earned under a prior agreement in exchange for the appellant's agreement to pay that 5% or make it up when it sold the subject property.
Counsel, you've described the contents of the agreement, but if it's not a real estate employment agreement, what is it?
It's just as the judge concluded, it's an agreement to make up the 5%. The statute,
what?
The 5% of the commission that was earned under the original agreement. But the term
real estate services, right?
That's what the original agreement contemplated. That's what DAWM provided, and that was concluded at the time the email agreement was entered into. The email agreement did not require DAWM to go out and either buy a property or sell a property, which is included in the statutory definition of a real estate employment agreement. Therefore, it's no different than a real estate broker entering into a variety of different contracts. Just because it's a real estate broker doesn't mean it's a real estate broker employment agreement.
Give us an example. A variety of different, give us an example what the realtor might do. Are you talking about maybe the realtor out of his own pocket might hire the pest control, pay for the pest control, the termite inspection?
That could be an example, or there could be all kinds of financing agreement, an agreement related to the broker's own lease. I mean, the statute is very clear as to what is a real estate employment agreement. It's an agreement between a broker and a client for the purposes of either purchasing or selling property. That
As you say that, as you say those words right there, I can't help but go right to the statute and think, okay, we have a broker, we have a buyer, we have purchase of property, and we have compensation. What am I missing there?
What that statement misses is the fact that the buying and selling of the property was already done pursuant to another contract. This agreement, the email contract, dealt with one thing: postponing a right to an immediate payment of 0.5% in exchange for the other party agreeing to pay it at a later date.
It seems like you're suggesting that you can only have one listing agreement or one compensation commission compensation agreement per transaction.
No, I guess theoretically you could have multiple ones, or you could have amendments of the original one, but this agreement was not either. It was an agreement that dealt solely with one issue. If you will agree not to accept payment of the 0.5% right now so we can close with this sale, we will pay it to you when we sell the property. Thus, it did not require the fundamental part of the statutory definition of a real estate employment agreement to go out and sell or buy a property. And I would just add to that none of the testimony that was given by Bob Lundstedt, the broker with Dom, compelled any different conclusion. Again, this separate email agreement was not for the purposes of buying or selling property.
How was it not for the purposes of buying and selling property, but for the agreement that wouldn't have closed? There wouldn't have been no sale on the original transaction. Agreed? The buyer was going to, or the seller was going to back out because they were undercapitalized. Isn't that where we are?
Well, that may or may not be, but the point is that the agreement that we're talking about is not an agreement that thereby compelled them to go out and sell property or buy property. It was something totally different than that.
But how is it not under the auspices of them being the broker, them brokering the transaction, them being involved, them providing services that are contemplated in the regulations of what a broker should and shouldn't do and what is required for a broker? That's what I'm not getting.
Well, I mean, again, if you think about the whole purpose of the statutory requirement for protecting customers against these brokerage agreements, unless they're in writing and the terms are set forth, obviously one of the things that's being contemplated is to protect people from long ago forgotten claims by brokers when a property transaction occurs. That's not the kind of issue we're dealing with here. First of all, the appellant did not ask the Dom to go out and buy or sell anything. They simply asked Dom to forgo the commission that was otherwise owed by the seller, not by the appellant, and that it would make that up later. Yes, did it facilitate the transaction? Yes. Did that call for real estate services? No. It was purely a financial agreement to defer a payment that had already been earned and was due if the transaction closed.
And the deferral was to the close of the next transaction?
Yes.
So is that not contingent on Dom selling the property?
No, because that was an entirely separate agreement. The appellant could have chose to use Dom to sell the property, or they could have used anybody else. And in fact, the listing agreement to sell the property had a definite expiration date. And let's say the property didn't sell and the listing agreement hadn't been renewed, Dom would still be entitled under the party's email agreement to payment of the 0.5% when it sold the property, regardless of whether Dom was entitled to a sales commission or not.
So it's your position that Dom would have reduced that 5% commission even if they didn't already have a listing agreement with Kathleen for the flip?
Well, what I think what would be more accurate and not outside the bounds of speculation would be to say when they agreed to the 5% deferral, clearly there was an understanding, because there had to be, that the listing agreement had an expiration date, and there could very well be a circumstance where the listing agreement would expire, and the only thing that Don would be entitled to at the sale of the property at some future date would be their 5%, the amount that had been agreed to be deferred under the September 24, 2012 agreement. All right. As to the remaining issues before Your Honors, the evidentiary record in the case supports the trial court's decisions. The appellant, we believe, has failed to establish that the trial court abused its discretion or that the appellant was prejudiced in any way by the purported errors.
Sorry, before we move on, I want to just clarify one thing. It sounds like what you're saying is even if we, assuming that we were to find that this was a real estate employment agreement, you believe all 4 statutory conditions are met, including a definite date. Could you walk me through those?
Yes,
4
of course. And we do address that in our brief. And our position is, even if you conclude it's a real estate employment agreement, there is a specific definite duration. The end date is when the property is sold. And under the facts and circumstances of what the parties were trying to accomplish, it couldn't have been anything else. In fact, appellant would be prejudiced if they had agreed to a specific calendar date, because the property may or may not have been sold.
What is your legal authority under that third, I guess, requirement that a specific event but not a specific time frame is sufficient?
We cited some cases dealing with general contract law from admittedly other jurisdictions dealing with that, and I would just point to the fact—
Are any of those real estate commission cases?
I don't believe that they are. And I also am cognizant of the red carpet decision, but I would point to the fact that because of the nature of this agreement was not one where there was a listing involved in the agreement, the whole purpose of having a calendar expiration date just makes no sense in this circumstances. As to everything else, our position, as we set forth in our brief, is that all of the statute of frauds requirements are met. I have no more prepared remarks, but I'm happy to address any further questions of the court.
Just one question. Why isn't the court's instruction on breach of fiduciary duty problematic?
Thank you, and I'm happy to address that, Judge Brown. First of all, to make very clear from the record, the appellant's counsel's position at the trial court level was not that they had an issue or a challenge to the parts of the instruction that were given, and that's very clear in the record that we cited to in our brief. Their objection was to the parts that were omitted. And with respect to that, Your Honor, the suggestion that if the court had been instructed that real estate brokers have a high duty of care to protect and promote the interest of the client, that somehow if that instruction had been given, the facts would have led to a different outcome. There's nothing in the record to support that conclusion. The simple facts were, and I think the facts that were dispositive to the judge, was that there was this advance notice on the sale transaction in 2014 that the appellant was made aware that there was going to be a 3-to-1 split between the 2 brokers involved, and there was nothing done, no objection made, no reservation of rights expressed with respect to that, and no evidence presented to show that somehow the appellant was prejudiced, other than this statement, well, we have a guarantee outstanding. The evidence was that, in fact, they were getting $1.6 million of rent per year. The evidence was that they were even thinking about not selling the property because the property was so profitable, that evidence just was not strong enough to merit some kind of instruction that somehow an omission had been made and that it was material in any respect.
Okay.
Out of curiosity, had they decided not to sell the property, what would your client's remedy have been?
As we indicated in our brief, the way the parties agreed to it, I don't think they would have been entitled to the 5% if the property hadn't been sold. That's the way they worded their email agreement. You will get paid the 5% when the property is sold.
Thank you.
Thank you.
Thank you.
Thank you, Your Honor. I think Judge Campbell hit on it. But for this deal, the property wouldn't have closed. The seller was playing hardball, And Mason Cave, my client's representative, said, hey, here's your 0.5 commission, go forth and negotiate and get this deal done. And so you have a classic brokerage services. And counsel now refers to it as a, quote, financial agreement now. In the complaint, this is the way they couched it. Again, verified by the designated broker. Plaintiff conferred a benefit upon defendants in the form of providing brokerage services in connection with the original sale of the property to defendants. It's just like they do it in all the cases. In Olson v. Neal, it's a waiver. In Red Carpet, they call it a finder's fee. There's another case called Musa, which is cited in Focus Point, M-O-U-S-A. I sound like Mickey Mouse here. But that's cited in Focus Point, and the Musa court said, hey, if they're non-brokerage services, then it doesn't fall within the statute. If they're brokerage services, it does. It's binary. They've admitted they're brokerage services. And in terms of the expiration date, it is very relevant. That deal might not have closed on those terms. That seller was doing all kinds of stuff. Seems like a very experienced seller who was grinding on everybody to reduce the terms. Nobody knows whether that deal would have closed. It did close, but if it didn't, right, they're saying that this 0.5 agreement is, hey, whenever you sell the property, we get 0.5. Even if you buy it under different terms. So, and it would go on forever. So it's not true that an expiration date isn't important. It's very important. And again, you look at the statutes, ARS 32, 2101, 48, and 50 define what a broker is, and they define what a real estate agent is and what they do. And they negotiate to buy and sell property. It wasn't negotiating to buy a ham sandwich. It was negotiating to buy property. So it falls right within the statute. You can call it anything you want, but the question is, does it fit within this? And courts for many, many years have said agreements where a broker tries to get a commission in connection with the purchase of property is subject to the statute of frauds. And I cited counsel's quite accurate article where if the statute of frauds applies, then the real estate employment agreement analysis goes into effect. You determine whether you met the four elements. They haven't met the definitive. And by the way, the statute says definite. It doesn't say implied. I believe it was Judge Perkins asking those questions about those other cases. Not only are they not Arizona cases, but they're implied endings. The statute in Arizona says definite, and it requires strict compliance. The Young v. Rose Court gave a great history of Arizona courts clamp down, whether it's a harsh result or not. And I don't think it's a harsh result in this case, and I'm out of time. I appreciate it.
All right. Thank you, counsel. We thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. At this time, we'll stand in recess for a minute to prepare the courtroom for the next argument. Thank you.